now what I'd like to do is to give each of you a minute, maybe 90 seconds, to express your ideas on the key takeaways for this event for our attendees to remember. So I'd like to do that in the order in which you presented. Megan, would you care to give us some of your thoughts?
Sure, thanks, Paul. And on my piece of the presentation, I think there are probably three key takeaways. The first on personnel is that Trump has now appointed the key leaders of both federal antitrust agencies, and both are well known to the antitrust bar. Indeed, both Delrahim and Simons worked in the government under George W. Bush administration, and so we shouldn't expect the agencies to veer too far from traditional antitrust principles, though I do say that with a bit of an asterisk, noting the AT&T Time Warner challenge is a pretty aggressive move, as Matt explained earlier in his helpful presentation. Second, on the legislation front, there is a lot more movement than we typically see on antitrust litigation, particularly from Democrats introducing legislation aimed at reducing concentration via mergers, or at least learning about the impacts of that concentration. And we should probably expect to see more movement on that front, though without controlling Congress, probably not much actual legislation coming out of it. The SMARTER Act, though, has bipartisan support, and I think its chances of passage do strike me as much more likely under the Trump administration. And then finally, on the role of the White House in antitrust enforcement, the reality is that we still really don't know and may never know what it's going to be. Trump has certainly been more aggressive in his public statements on this front, but his team remains steadfast that he is not communicating directly with DOJ personnel. And I think that's all on my front. Matt?
Those are great takeaways. I agree with all of those, and I think to just add that so far what we've seen from DOJ is that they are being very active, and that this new regime is very willing to litigate. That's something that, for those who are new to the antitrust space is not always common and expected. And so I think that's one takeaway, is that parties have to be conscious of DOJ's willingness to litigate under this current regime. And then second, I think the other big takeaway is the value of having a creative approach to merger review, and clearly with DOJ's emphasis on a new theory of harm, they are taking an innovative approach themselves. And so relying on past precedent maybe isn't as sufficient as it once was before, especially given how AT&T Time Warner has been a surprise to the industry.